Good afternoon. Welcome to today's AFG Dial-In webinar, Mitigating Legal Risks of Association Foundations, ESG, and DEIA Programs. I'm Ebony Clay, Assistant Director of Programs and Development for AMCP Foundation. I will be your moderator today. This month, AFG explores the legal risks of AFG explores the legal risk inherent with ESG-related initiatives for nonprofits, from employment law to contracts to state laws and orders restricting DEIA initiatives to misrepresentation and greenwashing to member derivative suits to data privacy and security. We will touch on it all today. You'll receive practical tips and guidance on how your organization can effectively mitigate these risks. Before we begin to dive into our program today, we would like to take a moment to say thank you to all of our loyal and generous supporters of AFG, especially the Stelter Group, the sponsor of our webinar series. Stelter provides plan giving marketing solutions and helps nonprofits improve plan giving strategy, donor cultivation, and closing gifts. You are not a member of AFG, we want to let you know that joining this elite group of Association Foundation professionals is easy. AFG provides content, resources, and community to Association Foundation executives and association fundraisers. I belong to AFG to network with other professionals, and I also love sharing ideas. Our next activity is a holiday open house. This at CCS fundraising at their offices at 1667 K Street Northwest, just off of Farragut North Metro stop. Light food and refreshments will be provided, and in the new year, the amazing AFG webinar will continue. Each month, we will tackle a different fundraising, executive management, personal branding, or association leadership topic. We invite you to actively participate in AFG, which can be done through social media by following us on Twitter at AFG_headquarters, AFG_HQ, and by joining the conversation using our hashtag AFGLearn. If you are interested in volunteering to participate on a committee, would like to be a presenter, or have an idea for an interesting topic, please reach out to us at info@associationfoundationgroup.org. And of course, if you're interested in furthering your engagement and connection with the Association Foundation community, please contact us about how we can customize a sponsorship investment for your company to get you in front of the right people. Now, it is my pleasure to introduce today's speaker, Jeff Tenenbaum. Jeff is one of the nation's leading nonprofit attorneys and also an accomplished author, lecturer, commentator, and expert witness on nonprofit legal matters. As managing partner of the nationally recognized Washington, D.C.-based Tenenbaum Law Group, a 5-attorney boutique law firm focused exclusively on the legal needs of nonprofits, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award, which he is only one of 5 lawyers in the U.S. Legal 500's Not-for-Profit Hall of Fame, and has been ranked Best Lawyer for Nonprofits and Charities Law by U.S. News and World Report every year since 2012. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, as well as the award-winning book, Quarantine Cocktails, and currently serves as chair of the American Bar Association's Trade and Professional Association Subcommittee and on the ASAE Legal Advisory Council and Public Policy Committee. Jeff, welcome to the AFG webinar, and thank you for joining us today. And I just want to let everyone know that as through Jeff's presentation, please feel free to submit your questions either through the Zoom Q&A functionality or through the chat box.
Thank you, Ebony.
You're welcome.
All right. Let us get started today. So welcome everyone. Thanks for joining today. First, before we get started, I'm going to paste an article in the chat that is all about the issues we're going to be talking about here today in even more detail than I'm going to be able to cover in this webinar. So I wanted to give that to you as a resource. You might have seen that article published by ASAE and American Bar Association and a couple other places, but this is a recently updated version. I've updated it with new developments. It's on our firm's website. And just so you know, on our firm's website, tenenbaumlegal.com, we have a whole host of resources on association and nonprofit legal issues, hundreds and hundreds of articles and PowerPoint presentations and recorded webinars on all different association and nonprofit legal issues. And we're constantly adding more. So feel free to visit that as a resource, including to view this article. So let's dive into this today. First off, I've spoken to your group a number of times in the past, although it's been quite a while. I've been practicing law now for 27 years, all of it exclusively representing associations and nonprofits. And I've had the pleasure of speaking to your group a number of times in the past, including in person when we used to host programs at the Venable Law Firm where I worked. But today we're going to dive into an issue that's really not been kind of a hot button association or nonprofit legal issue in recent years or really ever, but one that I've been kind of seeing kind of bubbling to the surface because of the way that legal developments in this field are evolving kind of outside the association and nonprofit world. But like most other things, it likely is going to, or already is, and it's likely going to continue to have an impact on legal risk and risk mitigation for associations and nonprofits, including related foundations of associations like the ones you guys represent. So let me give you a little backdrop, and then I'm going to dive into some of the specific legal risks. And then I think the most important part of any webinar like this or any article is what can you do to mitigate those risks? What are the good practical tips and suggestions to mitigate the risks in this area? And that's what I hope you take away from this. I encourage you to ask questions throughout. Just pose them in the chat or the Q&A. Ebony will be monitoring that, and will pose the questions to me as they come up, but no reason to wait till the end. So first off, what is this all about? So ESG stands for environmental, social, and governance. And this is an area that in the past has been really relegated to publicly traded companies in the US. And there are a number of specific mandates in the environmental, social, and governance area for publicly traded companies that are enforced and regulated by the Federal Securities and Exchange Commission, the Federal Trade Commission, and state attorneys general. And that's always kind of been the focus of the ESG. And the idea is to require, in some cases, larger for-profit publicly traded businesses to care about environmental, social, and governance issues beyond just the bottom line. Environmental issues such as climate change and resource depletion, waste and pollution, social issues such as working conditions, employee relations, diversity, health and safety, and then governance, things like board diversity and board structure, executive compensation, and corporate ethics. Now, ESG as regulated in that manner is not anything that associations have had to deal with. However, associations and nonprofits, not all of them, not even most of them, but a number are increasingly adopting ESG type principles and practices in their own operations and organizational structure, again, in order to help reflect their important priorities and values. And we're going to get into that further. Now, the title of this program refers to ESG and DEIA. DEIA stands for Diversity, Equity, Inclusion, and Accessibility. The way that I look at it is ESG is this broader kind of category of initiatives, programs, requirements, self-imposed requirements in some cases, and then DEIA is kind of a subset of that. So DEIA is part of ESG, but it's only a subset of it. Now, DEIA initiatives have, in the nonprofit world, kind of involved fostering the hiring and promotion of African American and other minority employees. They've been prominent in corporate America for many years. For-profit companies, as I'm sure you know and read about, have been under enormous scrutiny as of late with regard to their hiring and promotion policies and practices from both sides of the aisle. And this is a newer development in recent years, but there's been pressure on for-profit companies from both sides of the aisle. In addition, a number of states have passed laws and issued executive orders, both requiring and in some cases even prohibiting DEI practices. And then most recently, the U.S. Supreme Court's June 2023 decision banning race-conscious college admissions, and especially the rationale that underlies that decision, have raised concerns about the ruling's potential broader applications, particularly in federal employment law, and perhaps even more broadly in connection with things like contracts, fellowships, scholarships, and internships, and the receipt of federal funds. And even in the absence of future court rulings, what we've seen, I've seen it in the association community, is a number of employers curtailing and or halting new diversity efforts in the workplace. So as I said, there's been this kind of growing attack on ESG and DEI from the political right, on corporate policies aimed at diversity in hiring and promotion and other social and environmental goals. We've seen a rash of lawsuits. We've seen agency investigations and requests for federal agency investigations. We've seen congressional investigations, public pressure, and in other ways. So what does all of this mean for nonprofits and associations? Associations and nonprofit tax-exempt organizations are at this point not subject to specific ESG regulatory requirements and standards like those that are applicable to for-profits and that are enforced by the SEC. But associations and nonprofits, some of them have voluntarily in recent years, and some for even longer, incorporated DEIA into their programs, their activities, their governance, their operations for many years, and are increasingly voluntarily incorporating even broader ESG principles and practices into their organization. Sometimes this comes from pressure from board members, members of an organization, employees, grant makers, donors, sponsors, advertisers, exhibitors, and sometimes other external third parties like consumer groups. They're also sometimes doing this in an effort to attract and retain a younger generation of staff that is increasingly sensitized to and very mindful of ESG principles. So what does all this mean from a legal perspective? I am an attorney, after all. I'm not here to argue for or against ESG or DEIA practices in your associations or nonprofits, but I am here to talk about if you decide, or if you are already incorporating ESG and DEIA practices and principles into your operations, into your governance, into your employment practices, into your organizational structure, into your DNA of your organization. How does this potentially expose you to legal jeopardy, and what can you do? What are some practical tips and suggestions to mitigate those risks? Because when you decide to voluntarily weave ESG principles and practices, including DEIA, into your kind of organizational and operational fabric, you are no doubt taking on a certain degree of legal risk. And that legal risk is very much evolving. From a legal perspective, this is a moving target, and I'm going to get into this a little bit, but what the legal landscape, the risk mitigation landscape looks like today is likely going to be very different a year from now, with likely additional U.S. Supreme Court decisions and other federal appellate court decisions in this area, and other just evolving practices, future lawsuits, future agency and congressional investigations, all of which is no doubt going to change the landscape. So one of the things I want you to keep in mind here is that kind of the risk profile I'm going to be talking about here today, the legal risks that you face in this area and what you can do about it, is going to be constantly evolving, likely even month after month. And so you need to really pay attention to these things, follow new developments, obviously work with your legal counsel to help mitigate these risks. But this is absolutely a moving target. So I've kind of broken this down into how many different areas? 1, 2, 3, 4, 5, kind of 6 different legal areas. And this is a non-exhaustive list. There are potentially other legal risks as well, but in putting this together, I kind of brainstormed 6 legal areas of risk. I'd say probably the first 3 are more, I don't want to say important, but prominent, and probably going to get more people's attention than the latter 3, but they're all important. So first is employment law. ESG initiatives, and especially those that involve DEIA issues, can involve changes to hiring and promotion practices in your workplaces, workplace diversity, employee compensation and benefits, all of which can trigger employment-related legal risks such as discrimination, harassment, and wrongful termination. This is nothing new. Laws like Title VII of the Federal Civil Rights Act and the state equivalents have been applied to association and nonprofit employers for over 50 years. But what is new is the potential impact of the U.S. Supreme Court's June 2023 ruling, Students for Fair Admissions versus Harvard and Students for Fair Admissions versus the University of North Carolina. They were combined, the two cases, into a single decision, which rejected race-conscious admissions in higher education. Now, the new decision alone on its face does not impede employers in any way from pursuing diversity in the workforce, as it is solely limited to higher education admissions. However, the rationale underlying that ruling, many experts have thought this, I thought this when I first read about the decision. As a practical matter, it's likely going to discourage some employers from putting in place ambitious diversity policies in hiring and promotion, or prompt them to rein in existing policies by encouraging new lawsuits in the employment arena under this new legal standard. And sure enough, almost 5 months, 6 months later after the ruling, that's exactly what's happened. And there's been a rash of lawsuits. I'm going to talk about some of them, essentially adopting the same U.S. Supreme Court rationale. And this is a very oversimplified analysis, but it's essentially outlawing, making illegal reverse discrimination. If you want to kind of really simplify to its most essence, it's more nuanced than that. It's more complicated than that. But that's really what this is all about. And it's not surprising that we're seeing a number of lawsuits, including some by some of the same organizations that were behind the lawsuits that led to the June 2023 ruling involving college admissions. Some of the same organizations bringing suits against employers and others, which we're going to talk about. So the logic kind of underlying that decision could threaten employer programs, including in the nonprofit space, that as of today can take race into account. So right now, under federal law, the way the courts have interpreted it, employers under federal law are allowed to employers are allowed to take race into account in situations such as if a racial minority was previously excluded from a job category, or to remove obstacles such as unconscious bias that prevent employers from having a more diverse workplace. That might change in the future. That might not be allowable in the future, depending on future Supreme Court decisions. But regardless, the more meaningful and immediate effect of the court's decision is likely going to be greater pressure on policies that were already on questionable legal ground, that really were not narrowly tailored in the way that is allowable, but that were broader. And a number of them exist, including, and sometimes even especially in the nonprofit community. We are aware of, a number of nonprofit organizations, employers that have like staff leadership acceleration programs or paid internship programs that are open only to members of underrepresented minority groups. Those are likely going to be at increased legal risk and jeopardy, and ones that you're going to want to take a really close look at. So again, in the employment law setting, an evolving target, but we know there are a number of high-profile cases that have been filed that are working their way through the courts. At least one of them will ultimately, in the employment area, end up at the U.S. Supreme Court, and just keep a close eye on the developments in that area. Now, a second area, which a lot of you might be surprised to hear about and have no idea about, but is also being influenced by the same wave that was generated by the June 2023 U.S. Supreme Court decision, is a very old section of federal law, which is Section 1981 of the Federal Civil Rights Act of 1866. So this was a law that was put in place when slavery was abolished to help protect African Americans from being discriminated against in contracting, in the making of contracts. And basically the law says it is illegal. This is under any sort of contract in the United States. It's illegal in order to discriminate on the basis of race in contracts. And keep in mind, this law only only relates to race, not to other protected characteristics. As you well know, under things like Title VII of the Federal Civil Rights Act of 1964, there's a whole host of protected characteristics well beyond race, such as gender and ethnicity and age and disability and so many other things. And then, of course, there are many state and local laws that also provide protections for other protected characteristics, such as sexual orientation and other things like that. This law relates solely to race discrimination, does not apply to other characteristics, but it has been around for a long time. It's still in place. And now, not surprisingly, a group called the American Alliance for Civil Rights filed lawsuits in August 2023, 2 months after the Supreme Court decision, against two national law firms that have operated paid diversity fellowship programs for many years aimed at bolstering diversity and inclusion in their attorney ranks. Coming from a big law firm for 20 years and knowing so many other big law firms, these kind of programs are not uncommon. It's well known that minority attorneys are they're a very small portion of especially big law firms, and there's been very notable and I think very worthwhile efforts to try to bolster diversity and inclusion in the ranks of attorneys generally and in big law especially. But these lawsuits allege that the paid fellowship programs, which are limited solely to certain underrepresented groups in the legal profession, such as students of color or those who identify as LGBTQ+, and those with disabilities, are a violation of Section 1981 because they illegally discriminate against students on the basis of their race, using the reverse discrimination rationale that underlies the U.S. Supreme Court's higher education decision. These are the allegations in the lawsuits. And because you might say, well, what does that have to do with contracting? But because the fellowships require students to enter into contracts with a law firm, as you would expect has to happen, it is not at all inconceivable that if these cases are successful, it could result in the prohibition of numerous association and nonprofit fellowship, scholarship, internship, and other programs where contracts are involved, aimed at increasing diversity and inclusion in the association workplace and in the industries and professions represented by associations and nonprofits. So, of course, we have the employment issues, which we just talked about, and there kind of this whole reverse discrimination rationale that underlied the U.S. Supreme Court decision may well be applied in the employment setting in a much broader way than just on the basis of race. But with respect to contracts, so here we're not talking about employees, where we're talking about other things, fellowships or scholarships or internships or other things that nonprofits and associations frequently offer, that you're going to have to keep an eye on how these lawsuits work their way through the courts and how the courts rule, because it's not inconceivable that some of these might be legally suspect, at least those that are provided, limited to people of a certain race. They could end up being held to be illegal. So you have to keep a close eye on those. So if you're thinking, oh boy, this is a lot to deal with, there's a third area. I'm sure you read about this. Most of it so far not directly applying to associations and nonprofits. Mostly, I'll explain this in a second, but that may well change moving forward. So effective July of last year, Florida passed the Florida Individual Freedom Act, often called the Stop Woke Law, that restricts diversity training in private Florida workplaces, including associations based in Florida and presumably Florida-based employees of associations that might be located elsewhere. So as I hope you know, the employment laws apply to employees based on where the employee principally works. So these days, especially post-COVID, with so many remote workers, so many associations and nonprofits have employees that work all over the country. If you have employees that work primarily from Florida, then they are likely going to be protected by this law. Now, this law is currently the subject of litigation. It's working its way through the courts, but this law is very strict in restricting any kind of diversity-related training in a Florida workplace or with respect to any Florida-based employees of your organization. So for those of you that are either based in Florida or have any Florida-based remote employees, you need to essentially not engage in any diversity, not require them or even allow them to go through any diversity training offered by your nonprofit organization.
Hey, Jeff, we have a question.
Yeah.
So the question is, do you have a sense of if and how these cases might impact the research grants or financial aid scholarship grants awarded? You touched a little on the scholarships and fellowships, et cetera, but is it reasonable to assume that other types of grants and awards could be affected by this?
Absolutely. And it's a good point. I'm actually going to, after we get off this webinar, I'm going to update the article to include that as well, because basically anything that involves a contract. So this is the Section 1981 issue. And if those are somehow limited or there's preference given to people of a certain race, that might well be held ultimately to be illegal if the U.S. Supreme Court's rationale from the June decision ends up being applied to Section 1981. Absolutely. Great question. Beyond Florida, in Texas Governor Abbott issued a memorandum to state agencies warning them to not use any DEI programs in hiring that are inconsistent with Texas law, and that includes setting diversity goals or interview targets for diverse candidates. So right now, it's basically an executive order. It's only limited to public employers in Texas, but it would not be surprising to see Governor Abbott at some point expand that to private employers in Texas, including any nonprofit that has employees that remote work from Texas. And then finally, California, I'm just giving a few of the highlights. There are some other ones. While California has adopted laws requiring certain racial and ethnic as well as gender diversity on boards of directors of public companies headquartered in California, both of those laws have been struck down by the courts and appeals are underway. But most observers expect to see a proliferation of these laws and executive orders restricting DEI policies, trainings, and practices in a variety of red states. And beyond the employment realm, it would not be surprising to see new state laws and executive orders that could effectively prohibit DEI initiatives in other aspects of association governance and management, such as board composition, volunteer leader selection, grant making, contracting, and government grants and contracts. So again, very much a moving target, very much new laws and orders we're going to see in various states in coming months and years. It's something you absolutely need to keep an eye on and stay on top of. So those are kind of the big three areas. The other three, like I said, not really anything new here in these other three areas, but risks that have always existed and that are very important to keep an eye on. So associations and nonprofits have always been subject to laws that prohibit kind of deceptive or misleading practices, in what you put out publicly. It could be marketing, it could be ads, it could be lobbying, it could be, it could be trying to sway public opinion on certain issues. And for years, for instance, as outside counsel, we've, reviewed certain ads and posts and other things that our clients put out to make sure that claims can be substantiated, right? That you're not making false or deceptive claims. Associations are subject to regulation in this area by the FTC. Non-association nonprofits are not, but all of them are subject to regulation by state attorneys general. Some of them get very aggressive in this area, and all of this is potentially subject to private litigation as well. And so in the ESG area, there's something called greenwashing. It's not really a term that's ever been applied in the association or nonprofit setting. It is to large for-profit publicly traded companies. And basically, this is instances of basically a large company publicly misrepresenting or overstating its ESG performance. And those same principles, those same regulatory requirements apply to associations and nonprofits as well. So you just want to be mindful if you're touting your successes and performance in the ESG area. You want to be mindful of these risks and make sure you're not making any misleading or non-substantiated claims in connection with all of your programs and activities beyond ESG, because the legal and the PR risk can be particularly acute in this area. Sorry for the background noise. There's some construction going on outside of my building. Fifth area is what I call member derivative suits. So this would be, for associations, not for, for instance, the related foundation of association, but for associations that have members, which most trade and professional associations do. There's always been something that's equivalent, the kind of the functional equivalent of a derivative suit. A derivative suit is for when shareholders of publicly traded companies, and it might even apply to non-publicly traded companies. I'm really not sure. That's outside of my wheelhouse. But it's when shareholders are allowed to bring a lawsuit essentially against the board of the company, saying that the board is mismanaging corporate resources or doing something other that's wasting corporate assets or acting imprudently or irresponsibly or something to that end. And in the association world, there's kind of the functional equivalent of a derivative suit by members, where members can bring such claims. And what does this mean, or how does this apply in the ESG area? Well, one of the things that a number of publicly traded companies have done has been, and actually some associations and nonprofits have done it as well, is to modify their investment policy statement to be more, for instance, environmentally friendly or consumer health friendly, and having policies that don't allow investments in certain types of products that harm consumers, like tobacco products or gun manufacturers or other things like that. That's nothing new. That's been around for a while. But as those sorts of ESG principles work their way even more into association and nonprofit investment strategies, investment policy statements, if an association ended up taking, say, a very significant material investment loss and a claim was made, which, by the way, some of the candidates running for the Republican nomination for president right now have made some of these sorts of allegations that certain companies have lost money because they've been too environmentally conscious and restrictive in their investment policies and investment policy statements. The same sort of suits could be brought against an association's board of directors or investment committee for allegedly not being a prudent steward of the organization's resources. These can also be brought by state attorneys general. And you would be more likely to see that in if you're in court. And from a state AG enforcement perspective for something like this, it's going to come from your state of incorporation, not where you're located. So if you're incorporated in a red state like Texas or Florida, the state attorney general of those states would have jurisdiction in this area. I'm not saying it's a high likelihood of such a suit, but something you should be aware of. So and we'll talk about kind of what do we do in all of these areas to mitigate your risk? And then finally, the last area is data privacy and security. Association ESG activities often involve, in part, collecting, processing, and storing sensitive data about volunteer leaders, employees, members, and other stakeholders. And just like with any other data pool, there's a risk of data breaches or mishandling of information, which could result in legal action, regulatory penalties, and of course, reputational harm. And if a data breach does occur, there's an ever-increasing web of requirements imposed by federal, state, and international laws that have to be followed. So those are kind of the legal risks you face in this area. What are the practical steps and things that you should do to mitigate those risks? So let's walk through it. And I've already kind of hinted and alluded to all of these things. But certainly, number one is the number one category of lawsuits and claims against associations and nonprofits is in the employment area. It's been that way for as long as I've been practicing law. It probably always will be. As such, you have to take compliance in the employment setting, as or more seriously than anything else, because from a legal risk perspective, it's your biggest risk area. There's no question about it. Cyber risk might be a close second these days, but in terms of litigation risk, it's certainly the biggest. And so you always want to make sure, for a wide variety of reasons, that your employment policies and practices are fully compliant with all current federal and state legal standards in the area involving things like discrimination, harassment, wrongful termination, and otherwise. Having outside HR experts or outside counsel who are expert in employment laws, coming in and doing audits of different aspects of your employment policies and practices can be a really important and helpful step in helping to mitigate that risk. You want to make sure in the ESG and DEIA area, making sure that any current and future employment diversity initiatives are narrowly tailored as permitted by current law and do not result in reverse discriminations. But it also means not overreacting to a June 2023 U.S. Supreme Court decision that right now does not apply in the employment setting, but keeping an eye on future legal developments. As I said before, for those of you that have remote workers in different states, remember that the state employment laws apply to an employee who works regularly from that state, regardless of where the employer is based. And so always be sure to consult with employment counsel that's fluid in both federal law and the laws of the different states. Those laws are very different. Just had an issue earlier today with an association client that has an employee that is resigning, but asked for a copy of the employee's personnel file. This is an area that's regulated by state law, not by federal law. That was my first question back to the client's representative that I was dealing with, is what state does the employee work from? So in all of these areas, and the laws of the states in the employment setting really vary significantly from state to state. Even in this DMV area where I'm located, DC, Maryland, Virginia, the employment laws in DC and Maryland are very different from the employment laws in Virginia, the latter which tends to be more employer friendly. And then finally, outside of the workplace setting, keep an eye on future rulings from the U.S. Supreme Court and federal appellate courts that could apply the rationale underlying that college admissions decision to other aspects of association governance and management, such as in connection with contracts, fellowships, scholarships, internships, research grants and awards, and federal funding. Regarding the Florida Stop Woke Act, as I said, it does restrict diversity-related training to nonprofits that are based in Florida, as well as to Florida-based employees of nonprofits, so be very cognizant of that. And keep an eye on how, especially in other red states, we might see an expansion of laws like the Florida law into other states as well as seeing an expansion of certain orders like the Texas order that only applies to public employers in Texas could easily and might well be applied to private employers in Texas, including remote workers that work in Texas. And obviously, outside the employment area, those same laws could potentially be applied to other aspects of association governance and management. With respect to public statements regarding your nonprofit's ESG performance, make sure they're fully substantiated with appropriate data and documentation, that they're accurate, and that they're not in any way overstated, misleading, or deceptive. On the investment front, working with a professional investment advisor, adopt an investment policy statement that reflects your organization's priorities, goals, risk tolerance, and financial needs, but that is defensible as being reasonable, prudent, and appropriate. And be sure to revisit it on a regular basis and update it as needed. Be sure to implement strong data privacy and security measures to protect sensitive information about association and nonprofit volunteer leaders, employees, members, and other stakeholders, to mitigate the risk of data breaches or the mishandling of that information. And if a data breach does occur, be sure to closely follow the ever-increasing requirements imposed by state, federal, and international laws. Lastly, a few broader tips. Be sure to develop clear and consistent ESG policies and practices that align with your organization's values, mission, and member and other stakeholder expectations. Regularly engage with stakeholders such as members and employees to ensure that your organization's ESG initiatives are transparent and meet their needs. Maintain up-to-date knowledge of all applicable federal, state, and international ESG-related laws and regulations and ensure full compliance with them. And as with all areas of legal risk management, work with experienced legal counsel to help your organization navigate the complex and clearly ever-changing legal landscape governing ESG initiatives. So that is what I wanted to kind of relate to you today, give you a lay of the land of kind of the evolving risk landscape in this area, give you some practical tips for mitigating that risk. So I'm going to stop there and see if anyone has any questions.
Actually, Jeff, I have a question. You mentioned before how currently it's not a requirement for nonprofits to incorporate ESG policies and practices, but some are voluntarily doing so. But do you feel like in the future, and maybe even the near future or in further out in the future, that this will be a requirement for nonprofits?
I mean, it's hard to, I don't have a crystal ball. It's really hard to say. We saw like California had enacted 2 laws that required more diverse representation on publicly traded companies that were headquartered in California. California and other blue states like that do have a tendency, or have a history, I should say, of enacting laws like that. Now, of course, those laws were struck down and appeals are working their way through the courts. But those are the type of laws that would not be surprising to see states like that in their legislatures or their governors through executive order, apply to nonprofit organizations. And we've seen hints or proposals of that, in the past through nonprofit corporate statutes. It's never really anything that's taken hold, but it wouldn't be surprising to see kind of elements of that through legislation or executive orders work their way in certain states. And then, of course, on the flip side, in the red states, I expect we're going to see, I absolutely predict we're going to see more laws and orders like what we've seen in Florida.
Good answer. Thank you. Then also another question that I had was, for the nonprofits that are voluntarily incorporating ESG, are they subject to corporate sustainability reporting directive, the CSRD, like for-profit organizations are?
No, absolutely not. No. And that's why when I kind of talked about the legal risks, I did not include that in there, just by voluntarily including ESG, incorporating ESG principles into your governance or your management and operations and whatnot does not make you subject to those laws, at least not right now.
Good point. We have a question. It says, Jeff, first, you're such a great resource for associations in this space, so thanks for being here. What kind of orientation should board members be given in these areas, as they will often be working with association staff? It's a great question.
Yeah, so it's always a great question, and not just in this area, but in so many other areas. Like I do a lot of, almost seems like once every other week, I'm doing some sort of a client, like a nonprofit or association board, kind of governance and legal training. And most of them tend to be fairly similar, focused on what does it mean to be like a board member of a tax-exempt nonprofit organization, explaining the difference between nonprofit and tax-exempt status, explaining the role of the board versus staff versus members versus committees, how to stay in your lane, talking about fiduciary duties that are owed by officers and directors and what does that mean, and how do you avoid breaching them, and then how board members can be protected from personal liability risk. So that's kind of this overall bucket of issues that, frankly, I think every nonprofit board needs to have either once a year or once every other year. It's so critical. It's always so well received. Obviously, each one is tailored to each organization, but beyond that, I get asked a lot, what sort of other trainings, should boards have? And look, there's a limit to how much you can do in terms of board training. I'm distinguishing it from staff training because I do a lot of staff trainings, my colleagues and I, on a whole variety of areas, things like, copyright and trademark compliance and how to make sure you don't engage in infringement and you maximize protection of your intellectual property, meeting contracts, tips for negotiating meeting contracts, for meeting staff, do trainings on things like unrelated business income tax issues for marketing and sponsorship staff, development staff who are charged with bringing in money to the organizations from corporate sponsorships and endorsements and other kind of corporate partners, and figuring out how to maximize the tax-free revenue from those initiatives. I do antitrust training for a lot of staffs. I've done that for a number of boards as well. But there's a line, like for instance, those staff trainings that I just talked about. Someone asked me once if I could do one. I think it was in the IP issues for a board, and I said to the client, I really didn't think it makes sense. Like that's a level of operational stuff that the board really should not be getting into, doesn't need to get into. So not every training that's appropriate for staff is appropriate for board, and sometimes vice versa. This is one where, I'm not quite sure yet. I think that if your board is very keen on enacting a lot of ESG and DEIA type principles into its activities, its operations, its governance, that's when I think it would be very worthwhile. So kind of a board that's a little more politically left-leaning and is more inclined to enact these kind of initiatives, I think they absolutely need to be aware of these risks and how to mitigate them. If it's a board, on the other hand, that's much more right-leaning and really has no desire and no interest and wouldn't even allow staff to go, beyond a certain point in enacting initiatives like this. I think it would be a waste of time and not really helpful or needed. So I know it's a nuanced answer, but that's my thoughts on it.
Thank you.
Oh, and I should add, since we did talk a lot about employment, trainings, not for boards, well, board training on things like unconscious bias and harassment is really, really important. And I cannot even tell you how many internal investigations we're doing these days for associations dealing with basically bad actors of boards acting badly in connection with association conferences. It's nothing new. It's been happening forever. But it just seems to be happening more and more. At least we're being brought in to do internal investigations, and doing good training for your boards and sometimes your other volunteer leaders in this area can be really important. But on the staff side, there are certain types of trainings in the employment area, of course, including things like anti-discrimination and harassment and unconscious bias training, which is really important. But also another area that I think gets short shrift, and it's important to help guard against discrimination and unfair termination and things like that. But performance management training for managers is really, really important. Teaching managers, the importance of setting clear expectations for everyone that they manage, holding them accountable to those, calling them on the carpet when they don't meet those expectations, sitting them down and explaining it, writing it into their personnel file, engaging in progressive discipline when you need it. These things instinctively, everyone says, oh yeah, I know that's what we're supposed to do. But the reality is, in most associations and nonprofits, it just doesn't get done by most managers. And then what happens is I get the call when the manager or the CEO or whoever wants to terminate the employee. And I look at it, and there's employee's been there for 7 years, and there's 7 years worth of pretty glowing performance evaluations and maximum raises and bonuses every year. And I'm hearing about what a poor performer the employee is, but it just wasn't reflected in the performance evaluations and how the employee was disciplined. And then it makes it very difficult to terminate that employee without risk, because it makes it a lot easier for the employee to say, no, the real reason I'm being terminated is because of my race or my gender or my sexual orientation or my age or whatever other protected characteristics they might have. And so I know this is a little outside the scope of this program today, but it's an important plug for performance management training for your managers.
Thank you for that.
Well, if no other questions, Emily, maybe should bring it to a close. Sorry, Danny, for making your head spin. a lot of people say that after I.
Well, I highly recommend you reading that article that he dropped in the chat.
And there's another topic I've been asked to speak on a lot these days, and I think I have one coming up tomorrow or next week, is on kind of AI, artificial intelligence, particularly generative AI and associations and nonprofits, and how associations and nonprofits can mitigate their legal risk from the use of generative AI by their employees and their volunteer leaders and their speakers and their authors and whatnot. And there's an article, several versions of it on our website on that topic if you're interested. And there's also a list of all of the upcoming speaking engagements that my colleagues and I are doing. And you'll see some on the generative AI stuff, as well as some recorded webinars on that topic as well, if you're interested. Someone asked, I just posted the article about ESG and DEIA again into the chat.
Great. I don't see any further questions, but nothing but great and glowing comments about how much how useful this information is. So thank you so much for joining us today, Jeff. And we definitely look forward to. We'll definitely all be looking for the court cases coming up. So we will. I'm I'm sure that we'll be reading plenty of these articles. And thank you again for joining us and being such a wonderful speaker. And if there are no more questions in the chat, I think that's it for today.
Thank you, Ebony, for having me. Thanks everyone for participating. I just posted the AI article in the chat as well. But thank you all for having me, and have a great rest of your week.
Thank you.